Good morning, everyone. I hope my sound is clear, and I want to welcome you to today's webinar. I'm very sorry for all the problems we've had with invitations. Our program, I don't know if I'm just the one who's not good at operating it, but I did experience a lot of problems, and I really hope everybody did get their invite in the end. In case one of your colleagues perhaps were supposed to be invited and something happened, they weren't, I hope you'll apologize on behalf of myself. If we can just look at the program, I think you already know it. I'll just talk for 1 minute, a short introduction, and then Crystal Clarko, who's the Senior Manager of a company's unit, will speak about the business rescue application and procedure. Then after that, Vuyani Mkogla, Senior Manager for Directors, Members and Practitioners Unit, will speak about licensing and appointment of business rescue practitioners. And thereafter, we will have a question and answer session. Some of your chats may be answered during the or during the presentations. However, some of them we will also try and answer in the question and answer session. And after that, we will be closing. So just as a very short introduction, I don't know whether you know what our objectives are as CIPC, but just in case you're not aware of everything we do or we're responsible for. The first one is efficient and effective registration of companies, cooperatives, and intellectual property rights, and the intellectual property being patents, designs, trademarks, and copyright. Then after registration, we also have to maintain the registers as changes is done. And then we need to provide the information to the public and organs of state on request. Then there's some promotion of education and awareness of companies and intellectual property laws and related matters. We do promotion of compliance to the Companies Act and related matters. And lastly, we're also responsible for enforcement of the Companies Act and related legislation. You can allow me 1 second here. I'm going to go out of the screen, and then Krista, you will be able to share your presentation that you can start. Krista, I think we're ready that you can start with your presentation.
All right. No, that's perfect. Let me just quickly coordinate all the little screens. Okay. Morning, everybody.
Morning.
Alma,
morning.
Thank you very much for the introduction. Some of you may know, I see some of the names popping up, and I sometimes have a cursory look into the business rescue mailbox. So some of the names look familiar. So it's actually nice to see everybody on this webinar. As some of you may know, I'm Krista Clarko. I'm the Senior Manager responsible for companies and close corporations at the CIPC, under which business rescue proceedings fall. What should be clearly noted at the CIPC is that business rescue is basically split between 2 divisions. The proceedings, which results in a status update, lies within my area. And then the appointment and the licensing, the accreditation of the practitioners lies with Mr. Vuyani Mkogla from the DMP department. So that's why we've got 2 separate presentations. But I'm going to start with the business rescue proceedings. It's very much application and process orientated. So we didn't know quite what to expect and what to prepare for. So all your comments and questions is actually going to help us to improve the presentations if we have to do any more of them. For example, what we can do is, Alma, just to take a note, is that depending on the type of questions that we get, we may update the presentations and then send out the final presentations out to all the attendees afterwards, if that's in order with everybody. Right, so
Yeah.
let me start. So we all know, and I think this is one of the big questions, and I think it's also one of the reasons why we got so many participants, is that the global pandemic and COVID-19 has severely impacted on our lives, not just our personal lives, but also the business environment. We all know of big companies that went into business rescue just before lockdown, some of them going during lockdown, and we may even see going forward some more of these big companies going into business rescue. But what is very important to note is that,
Krista,
yes,
sorry for interrupting a second. May I just ask that everybody just turn off their mics, because we do hear some sounds and I don't think it is at your house. So I do want to ask during this presentation and Buyani's presentation that everybody just keep their mics muted. I'm also going to mute my own. Thank you.
no, thank you, Alma. So, so the trick is basically is to rather consider your position and the options available before it gets too bad. And I think in South Africa we tend to wait a little bit too late to make our decisions. And we don't, especially on the smaller businesses, we realize that they don't really monitor their financial positions as accurately as they should in order to act sooner rather than later. So when it comes to your business and your financial difficulties, there's various options that the Companies Act provide for. Although this presentation only focuses on business rescue, you can actually look at liquidation, deregistration even, deregistration in the sense that if you've got enough assets and cash flow to cover all your debt, you can actually liquidate and create an empty shell and then apply for voluntary deregistration. And then also you can go into a compromise with your creditors. You can then also consider business rescue. Just to add to what Alma's presentation saying, the mandate of the CIPC a little bit further regarding business rescue. One of the purposes of the Companies Act is to provide for the efficient and responsible rescue and recovery of financially distressed companies in a manner that balances the rights and interests of all relevant stakeholders. So, and as we all know, balancing, especially from the practitioners, I think you can all attest to it, trying to balance all these rights and interests, especially on the bigger companies, can become very, very difficult at some times. So our functions as the CIPC when it comes to business rescue is to manage and report the filings of the relevant notices, the accreditation of professional bodies. Buyani will speak more to that. Licensing of individuals that meets the criteria of the Act. Buyani will also speak about that. Monitor patterns of compliance, promotion of business rescue to the provisions of the Act, as well as an advisory role and an awareness role. What should be noted, especially from the practitioner side, is we get a lot of correspondence on the business rescue mailbox. And we're getting CC'd in between correspondence between affected parties, between the lawyers and the practitioners to the lawyers. And I would just like to put a friendly request through is please don't copy us into your correspondence, please. If you have something that you want to raise with us, please do so directly. Don't CC us in. We're not going to react on things that we are copied into. If you've got a question or something that you want to raise, please don't put your questions to the business rescue mailbox. It is becoming to a point where we cannot really administer mailbox anymore. It's too much. Please, if you've got a question, please and we'll assist you from there. Right. Like everything in life, there is a life cycle to business rescue. You've got the starting of the business rescue proceedings, practitioner. Then, if that is done successfully, the practitioner will assess the entity affairs. Once he's done the assessment, You will start preparing the business rescue plan in consultation with all the different affected parties. We'll get the plan approved, implement the plan, and then once the plan is implemented, file the substantial implementation. But what should be noted through this cycle is that at any given point, there is an exit point via the terminations. Just before we start, is just a few brief definitions. Most of you may already know these definitions, so please bear with me if you do. There's only three very core definitions. Affected person is basically any person who is affected by the decision of the company. That is a shareholder, creditors, registered trade unions, and even the employee representatives and the employees. We actually have got one or two cases where the trade unions were successful in going to court and putting companies and CCs into business rescue. Then also the definition of business rescue. It's the proceedings to facilitate the rehabilitation of a company that's financially distressed by providing for the temporary supervision of the company, its affairs, its business, its property, the temporary moratorium on the rights of claimants. What we're also picking up, that a lot of companies go into business rescue just for the moratorium, just to get away from the claimants, and then when the practitioners comes in, they assess the affairs, they realize but the company is actually not distressed and is not suited to go through the business rescue process. Also, the development and implementation of a plan to either rescue the business by restructuring it, or to provide for a better return for the company's creditors or shareholders than would have resulted from the liquidation process. Very interesting to note at this point is there is no definition of a successful business rescue. At a lot of committees, we tend to talk about what are we going to define as successful, and it's very, very difficult. And I think it depends on the business itself, whether the proceedings itself has met the expectations or the purpose of commencing the process as to whether it's successful. So successful may have a very subjective element to it. Then again, financially distressed, it appears to be reasonably unlikely that the company will be able to pay its debts as they become due and payable within the immediate ensuing 6 months. So financial distress is not you are distressed now, you've got financial difficulties right at the moment. If you do your business forecasting and you look into the future and realize within the next six or 8 months, I'm going to start having problems, then business rescue, you will meet the requirements of financially distress in order to commence the process. So as you have seen, I'm just going to repeat myself quickly. So the main purpose of business rescue is to restructure the business in order for it to continue on a solvent basis in a lesser manner than it was before, to provide a better return to creditors or shareholders. Then we'll go down a little bit more deeper. There's two ways of starting business rescue in terms of the Companies Act. It's where the company or closed corporation resolves to commence business rescue, or it's done by court order. Just a note, we use company, business, and entity interchangeably. When we talk about that, it includes companies, closed corporations. It does not include cooperatives or external companies for the purposes of business rescue. There has been a recent court case whereby it was found that that confirmed our position that business rescue, external companies cannot commence business rescue as defined in Chapter 6 of the Companies Act. All right, so we've already done that one. So just a quick overview of the filing process for when the company resolves to commence business rescue. So the entity resolves or makes it a resolution to commence business rescue. It submits the necessary documentation to us as the CIPC via the mailbox. We will then confirm the correctness and the effective date. when we go through the correctness, we actually read the resolutions and we actually do read the affidavits. As some of you may have realized, we sometimes refer the documentation back because the affidavit may be lacking in content or the resolution doesn't state clearly certain items, but I'll explain that a little bit in more detail further along. So once we have confirmed, we'll give you a confirmation, and I think a lot of the practitioners are curious to know as to why we changed our way that we provide our confirmation. Then once we've given the confirmation to the entity or the person that has submitted the documentation to us, the company must notice to the affected parties that the proceedings has commenced. So as soon as we have confirmed the documents and give out, say that it takes effect on a specific date, that's the date that the moratorium and the supervision occurs.
Just try it for a second when she pauses.
It doesn't occur when the practitioner is appointed. It is as soon as we have actually confirmed the correctness of the documents and have assigned the effective date. So the entity then will give notice. The entity will also then appoint its BRP. Very important for those that are not in the business sphere or the practitioners. CIPC does not appoint the practitioner. It is the company or the entity itself, but Fiani will give more detail on that. Then the entity will submit to us the call 123.2. So we as CIPC will then license, and then the entity needs to give notice regarding the appointment of the practitioner to all the affected parties. Just to confirm the requirements for the 123.1, fully completed call 123.1. It's an affidavit or the sworn statement. There is a slide specifically as to what we are looking for in terms of the affidavit. There must be a special resolution, not a resolution, a special resolution. And the resolution must state the entity is financially distressed and it resolves to commence business rescue proceedings. And that's it. And the documents must be filed. We're looking specifically for the statement in the resolution that it's financially distressed and that it's commencing business rescue proceedings, as well as we're looking for, sorry, I didn't put it in the presentation, we're looking for the fact to say that there is a reasonable prospect for business rescue to actually commence. It must be distressed and there must be a reasonable prospect to rescue it. Of course, we always need certified ID copies of the customer code, the person who submitted it, the person that undertook the affidavit. Then we also need the PI score of the company at the time that the decision was taken to commence business rescue. The PI score has got multiple purposes. Firstly, it gives us an indication of how big the company is, and also helps us to guide as to the level of expertise that the relevant practitioner requires. Also very interesting, we get questions about the PI score as to how many companies are larger companies, which are medium, and then we usually use the PI score in order to determine that. We need the primary business activities as per the C codes of SASH, please. Sometimes we have to guess a little bit of where it falls into the C codes. And the reason why we need the primary business activities is because we monitor the industries in terms of which business rescue is commencing. Then we also need the nomination of the business rescue practitioner. We also need a letter from the business rescue practitioner declaring his capacity to accept the nomination, his independence from the entity, and that the practitioner is not disqualified to do so. So once all of those documentation is ready, it can be submitted to business rescue at cipc.co.za. And again, please, it must be submitted as a single application. You can imagine if we get correspondence and status reports and terminations and court orders all in the same mailbox, and
okay.
the matters comes in drips and drabs. So please, it must be a full set. Even if we referred your documentation
Okay,
back
I thought
in more
maybe okay. I
detail,
was just
you
thinking
have to
people are typing
resubmit the
questions there.
entire application as a whole, just to make it easier for us to keep everything together.
Okay.
Then also we, earlier this year, we updated our practice notes regarding the requirements. Practice note 1 of 2020 is the new practice note regarding the requirements for business rescue. It also states the requirements for terminations. We need some more supporting documents in that area, as well as the substantial implementations.
Okay.
Right. All know, most of us know how an affidavit should look like, cause the financial distress. We are going to refer affidavits back if it doesn't state the cause of the financial distress. What's important to note is that this whole batch of documents that you prepare, you give it to the affected parties. And if it's a half-pager affidavit that doesn't give enough information, how can your affected parties actually make an informed decision? So rather a little bit more detail than a half a page that doesn't add value. Then they also need to state how the entity aims to rescue the company. You cannot expect everything from the practitioner. You at least need to have an idea of what you want to do. The physical address where the company has undertaken the bulk of its business activities. The reason for that is we also track the provinces and cities and towns where proceedings are commencing. Then we also need a list of all the legal proceedings the company is involved in and the nature of such proceedings and the status thereof. Very important, we actually look at it is if we pick up that liquidation proceedings has been initiated meaning that the court has stamped the notice of motion for liquidation proceedings, then we will not put it into business rescue. It's a requirement that liquidation proceedings should not have been initiated. We actually, interesting enough, had a case, I think it's about 2 years ago, whereby it was disputed because the resolution and the initiation by court all happened on the same day. And we actually had to go onto the time during the day, which process was followed in order to see which one came first and which one we need to act upon. So by court order, it's relatively a little bit the same. So the court commences the business rescue. It appoints the interim business rescue practitioner. The relevant documents, the 123.1 and court order must be submitted. Please don't submit us. Rule NISI is confirmed. Again, we will not know what the rule NISI was in the first place. So please make sure that everything is clear for us to say that the proceedings has commenced. We will process the court order. The entity then have to give notice to the affected parties of the commencement. The entity will then have to confirm the appointment of the interim business rescue practitioner or appoint a new one. Then again, the necessary documentation for the appointment of the business rescue practitioner is submitted to us. It's endorsed, and then the entity needs to give notice again regarding the appointment of the practitioner. Right. Conditions for a court order. You cannot approach a court order if the entity has already resolved to commence business rescue. I know it makes common sense, but unfortunately, we do get cases whereby court orders are done while it was actually resolved. And no application should have been made to the court for the liquidation of the company. I know a lot of the practitioners, some of your frustrations may be is that because of the overlap of decision-making and creditors making a decision to approach the court, some of these things are so closely overlapped. By the time that the documentation are submitted, you don't actually know that the day before liquidation proceedings were initiated. Just again, the effect, there's a general moratorium, the protection of property rights. The employees of the entity at the time of business rescue continue to be employed. Of course, there are certain exceptions to it. The BRP may suspend any obligation of the entity for the duration of the business rescue. Of course, again, there's exceptions to the rule. There's an effect on shareholders and directors as well. Alterations in the status of issued securities is invalid. and each director must continue to function as a director subject under the supervision of the BRP. Just something to note is once the entity is in business rescue and you want to change a director or you need to change the MOI, convert the CC to a company. When you do that, that must be done under the practitioner himself. You can't use our automated systems for those changes because we need to make double sure that the practitioner, that all these decisions are made under the ambit or the authority of the practitioner. So those need to be filed manually with us if those changes actually occur. All right, so the just overview of the BRP task, Vianney will give more detail to it. That person takes full management of the entity. For those that are not in the business rescue environment and maybe considering business rescue, please note, this is my analogy. Once you go into business rescue, you become a passenger with the rest. With SAS, the bank becomes a passenger and the practitioner takes over the driving of the bus. And unfortunately, you can't always dictate to the bus driver what you want to do. So please note, when you go into business rescue, the practitioner takes over full management of the entity. I know some of the practitioners, you feel sometimes very frustrated, a lot of members, because the businesses are their little babies and we get personally attached to our businesses. A lot of directors and members struggle to let go once the practitioner is appointed in order to take over the affairs and try to rescue the business. He also has she has the responsibility to develop the business rescue plan and to implement it. The practitioner is an officer of the court and has the same responsibilities, duties and liabilities as a director of a company. As soon as possible, the business rescue practitioner must investigate the entity affairs and decide whether to exit, whether there exists a reasonable prospect. But again, we'll go through that in more detail. The outcome of the assessment will be no reasonable prospect of success, so hopelessly insolvent, apply to court for discontinuation of the business. It's in the latter slides, but before I forget, we get a lot of times that practitioners submit the termination with a note to say that they're going to approach the court. Please note that as soon as you as the practitioner submitted the 125.2, you end your office as business rescue practitioner, and therefore you may not necessarily have locus standi to approach the court and to go for liquidation. So therefore our advice is always to go for the liquidation, and once the liquidation has been authorized or provided the court has decided to place the company or enter into liquidation, then submit the court order to us. So if it's no longer financially distressed, also file the termination. Very interesting in this area is that if the proceedings commenced by court order and you find that there is no longer financially distressed, you actually need a court order to terminate the proceedings. That is section 141(2)(b)(1) of the Act. Then financial distressed and prospect to exit. Right, legal consequences. The business rescue proceedings commences on the date of application is submitted with the CIPC. So let's say, for example, you submit today, but we only process it tomorrow. If it meets the legal requirements, we will backdate to the date that we actually received it in our mailbox. Not by when you logged a ticket, it's when it was submitted into our mailbox. If there was liquidation proceedings, then the resolution to commence business rescue is void ab initio. We will actually request practitioners that when you pick up that there is liquidation proceedings, please notify us. We don't always know this, so it's better just to let us know that we can update our registry. Of course, if the resolution and the effective date is not published or the practitioner is not appointed in the right time period, or within the extended time periods that has been applied for and we have granted, then it becomes a nullity. Once the entity, the proceedings has become a nullity, the company cannot resolve again to go into business rescue for a period of 3 months unless the court decides otherwise. Just a summary of the nullity, just for the benefit of time, I'm not going to go through that again. All right, so the assessment of the affairs we have already touched on. So as soon as the practitioner is appointed, he must investigate the affairs of the entity. If the entity is not distressed, file a Core 125.2. If the entity is too distressed, apply to court for discontinuation of the business rescue proceedings as stated. Don't file the Core 125.2 and saying you're going to court. Rather go to court, get the liquidation order, and then come back with an order in order to end the proceedings. If the entity is distressed and there's a reasonable prospect, then please continue with the plan and have it approved. Just a note on the Core 125.2. The published form itself doesn't make provision for all the reasons of termination. So please don't, I'm picking it up because we're picking it up that people keep to the standard of the published legal form of the 125.2. If the reason is not stated, just scratch it out and make a handwritten note to actually say what was the true reason for termination in terms of what section it was terminated. Some of the business rescue practitioners, you make our lives a lot easier when you actually file the 125.2 as well as a report and a letter to clarify things. Refer to practice note 1 of 2020. We have put in place some additional requirements for 125.2s. We're picking up a lot of practitioners are terminating proceedings and then they communicate something else to the affected parties. So we are starting to require additional confirmation of the reason for termination of the proceedings. As I stated before, the practitioner has assessed the affairs and found that there's reasonable prospect to rescue and it is financially distressed. The practitioner will then continue to consult with all the creditors and the affected parties and then prepare the necessary business rescue plan that he will then submit to everybody for a vote.
From the bottom of the list.
The content of the business rescue plan is clearly set into Section 150 of the Companies Act. Something to note as well, there's no legal requirement for the filing of the plan to the CIPC. Right? So you don't have to submit the proof plan to us. Also note that if you do submit the business rescue plan to us, because we are a public registry, anything that we receive, we can make publicly available upon request if we received it. So unless it's been declared confidential. So just bear that in mind with the business rescue plans. All right, if the business rescue plan is not adopted and no further steps has been taken to approve it, then the proceedings must also be terminated via a Core 125.2. Okay, I've already stated this, the termination of the proceedings. All right, the implementation of the plan. So as soon as the plan is approved, you need to implement the plan in terms of Section 152. Once the plan is substantially implemented, then the notice of substantial implementation must be filed with CIPC. We also request that the PI score at the time of making the decision that the matter is now substantially implemented, the plan has been substantially implemented, must also be provided. And then, of course, if the business rescue proceedings has not ended within 3 months, then we need to submit the 125.1 every month at month 4 and onwards. Again, some of you actually do a lot of effort in actually providing us with a more detailed plan because you need to also submit the status report to the affected parties. So thank you for those that are actually doing it. It provides a lot more transparency at what's going on. All right, so my last slide is, as soon as with a substantial implementation, you submit the 125.3 with us with the latest BI score at the time that you resolved that the plan was substantially implemented. So from my side, that is basically the proceedings. I know it's a mouthful, but yes, so thank you very much.
I think you will just have to say to me when I must move from slide to slide. So if you can just give an indication, but I'll try and, because I'm just scared I might move before you're ready.
Okay.
But you're welcome to start.
Thank you so much. You can move to the next slide whilst I'm introducing myself. Welcome to everyone. It is so encouraging to see 202 people having joined this webinar. We hope that we are going to get some information that will assist us to better the way we do things at CIPC. The purpose of this presentation is just to shed some light with regards to the licensing. But we'll try and explain much as possible. And if we repeat, you'll bear with us because of the nature of things. Can we get to the next slide? So this is the legislative framework that we are using that guides us in terms of the Chapter 6 of the Companies Act that deals with the business rescue. Next. Yeah, so as the Commission, a model for accreditation was established, which was based on Regulations 126 around 2017. The reason for this was that, number one, it is prescribed in the Act that the Commission must then accredit the professions in accounting, legal, and business management. Number two, also, it became one of the ministerial priorities to ensure that the business rescue space is more regulated, it is monitored, and also attention is given to it for various reasons that Krista has mentioned, saving of jobs, ensuring that the economy must in terms of COVID-19.
Let me invite you.
Now, in terms of this accreditation model, it was established. It was long overdue due to some constraints within the organization in terms of establishing it. But we established it, we already had a committee which was comprising of people that had an interest in the business rescue. And basically, majority of them were coming from the professional bodies. And that then gave birth to this accreditation, because these committees or these members, they also assisted in terms of the information which one would then require in order to ensure that we get the credible professional bodies that will be accredited by CIPC. At the moment, we have 13 professions that are accredited, and we also issue out licenses in terms of the Section 138 of the Companies Act. And at the time of this presentation, we had 315 licensed business rescue practitioners. Next slide. Now, as Krista has alluded to the process of the business rescue, the proceedings, the same applies also then to how these practitioners are being appointed. It's either the proceedings are informed by Section 129, or Section 131, which is the court order. Now, within 5 days after then, the companies adopted and filed a resolution with us, or any period that is longer, based on the application made to the commission. Then the company must appoint the business rescue practitioner in line with Section 138. And then after that appointment has been made, then the company must file a notice of appointment within 2 days with us in the form of a COR 123.2. Now, as you might have noticed that there is a unit that deals with the business rescue proceedings, and there's a unit that deals with the business rescue practitioners. Therefore, it also requires that we file these applications on the correct email addresses. For an example, if there's an appointment, there's an appointment for a practitioner, the email address that is used, it is cor123.2@cipc.co.za. And if there is an application for a license, the email address, it is cor126.1@cipc.co.za. But we will share these slides so that people may keep this information handy. The next slide. Now, we will appreciate that Section 138 does not deal precisely with the skills and the competencies of the business rescue practitioners. And Regulations 126, in a way, does give some hint that the commissioner must look at the applicant's education as well as experience that will be sufficient to equip that particular practitioner to perform the functions of the business rescue. Now, as a commissioner, we're in the process now of coming up with the competency framework for the business rescue practitioners. It is so unfortunate that this COVID-19 caught us by surprise, and it divided our attention. Currently, at the present moment, we are having what we called a continuous professional development, which is in place for all those practitioners, and their professional bodies will then ensure that people, they undertake these courses that are relevant also to business rescue, complete their great hours, and at the end of this year, all the professional bodies will have then to report in terms of their members, the conduct, as well as whether they have completed the necessary hours required. And this will have a bearing on the licensing of the practitioners. The next slide. So these are the email addresses that we use for our unit. So to apply for a license, an application must be sent to cor126.1@cipc.co.za. To file for the appointment, then the form must be sent to cor123.2@cipc.co.za. And the queries or inquiries, then they must be submitted through our inquiries platform that is available on the website. We also encourage practitioners to make use of their professional bodies if they want to raise any issues, and because those will assist us and form the agenda item for the Business Rescue Liaison Committee, which meets quarterly. We know that we are behind now, and plans are in place so that we have our a virtual meeting, because we meet quarterly. And as soon as our infrastructure is up to scratch, we will convene that particular meeting. And we also update information pertaining to business rescue practitioners and make it available on our website, on the publications, in terms of the practitioners, and also in terms of their categories, junior, senior, and experience. Next slide. Oh, that's the end, and thank you so much for the opportunity.
Unless we unmute everyone.
Sorry, but Carl must unmute himself, eh? He can do it himself.
Yes.
Hi, good morning. Can you hear me?
Yes. Sorry, if I may just ask, is Carl ready to give us his question?
Yes, if you can hear me.
Yes, you're welcome to ask your question.
Okay, good morning. I just want to know about the renewal from the business practitioners after the 3 years. How do we do that? Is that with the CBD? And then also there was another question on the group about the upgrades, because most of the people are being junior BRPs. How do we upgrade to handle larger companies?
So currently we have a license that has a duration, so it's a 3-year period. So after that, then the applicants will send the request for what we would consider would be the conduct of the practitioner during this period. We'll also consider the number of practices and the practitioner's involvement during this period, because it can happen that the practitioner is renewing the license based on the end of the period, but the practitioner was not involved, or the practitioner we had a lot of problems and probably the practitioner is still under investigation. So those are the things that will be considered when we do the conduct and when we do the renewal of the practitioner. Now, when it comes to the second part, the practitioner this category is derived from the number of years or the experience that the practitioner accumulates. Yeah. The regulation at 127, then it gives the number of years that the practitioner must have in order to be an experience, and also the number the practitioner must have in order for that practitioner to be a senior. So from 0 to 5 years, then you're a junior. From then 5 to 10 years, then you're an experience. Then 10 years upward, you are a senior. So that's what we consider. So if then the practitioner has not accumulated the number of experience required in terms of the regulations, then that practitioner will not go to the next phase. We have seen some of the practitioners that a practitioner was probably licensed in 2018, now is coming and says he requests to be a senior, which is not possible, because he has to accumulate a number of years in that particular category so that the practitioner can then be in a position to go to the next level. Thanks.
Okay, thank you. Carl, did that answer your question, or did you want to ask something further?
No, thank you. That's 100%.
Okay. Then I want to give Joseph a chance. I see his hand is up, so I'm going to lower his hand. Joseph, you're welcome to answer your question. Ask your question.
Sorry, this is a question for Mr. Nkoshla again. Just during a voluntary business rescue proceeding, does SIPC find it compliant with the Companies Act and regulations for the appointment of a BRP to be done simultaneously with them applying for accreditation and licensing? Or does SIPC want to first see that BRP is licensed before they'll consider any appointment? I just want to understand which event comes first, chicken or egg or chicken. Just want to understand that. Thanks.
Yes, yeah. So if we are to do it correctly in terms of Section 138, then it will say that the appointment must be a person who belongs to a professional body that is in good standing. And secondly, this very same person must be licensed by CIPC and will not have been disqualified, and also does not have relations, all those things that are identified there. And those things must be read cumulatively. It is so unfortunate that you will find some of the applications being done simultaneously. And I also even made mention of how the appointment must take place. You'll find that the resolution for a company to be placed in business rescue, sometimes it's filed together with the appointment, and sometimes together with the application for license, which is not correct in terms of the Act. And we normally guide people to say that this is the process. And but because of sometimes we need to appreciate and understand the urgency of this business rescue, so we try to assist as much as possible. But the correct way is that a person can be appointed when that person is licensed with the CIPC and is a member in good standing of a professional body and is not under any probation and is not disqualified and.
Thank you, sir.
Back to you, Alma. Elma, are you there?
Sorry about that. Maputi, you put up your hand and you're welcome to ask your question.
Thank you. On the question of CPD, how does it work with the professional bodies? Is there a declaration that we need to sign on an annual basis to confirm that indeed we did the business rescue related CPD?
Yeah, so I would then request that the people should consult their professional bodies, because they might not have the same way of doing it, but professional bodies, we have agreed on the principle of CPDs, the number of hours, and also the reporting period. And I would then suggest that members should go back to their professional bodies so that they find out how they're going to do this. Probably there's a form that they complete or a declaration, I would not know.
Okay, Maputi, did that answer your question?
Yes, it did.
Okay, thank you. Next, I want to give Ufense a chance. He's next on our list.
Hello.
Yes, please ask your question.
Am I audible enough?
Yes, we can hear you clearly.
Perfect. I wanted to understand something, and please, my apologies for taking you guys back. I might have missed in some information. It's relating to the application for a license. Now, as far as I remember, for a junior designation, you would obviously have to have perhaps 0 to 5 years experience. Now, in the cases where one is has been practicing as an attorney and a liquidator, but has not as yet had exposure in business rescue, but would like to apply for a license, and they are also obviously part of a professional body. What can what are the steps that one can take to get to maybe perhaps amongst other things to attach certain documents when applying for the license? I just want clarity on that, if you have no experience in the business rescue industry.
Yeah, so if you don't have any experience, then it means you're a junior. In terms of submitting, remember you attached for an example your CV and also with any supporting documents, and all that you need to do is to demonstrate your experience either in the business turnaround or in business rescue. And if you don't have neither of the two, then it means that then your experience will be based on what you have. And it's clear in terms of the act, it's not the working experience that we're looking for, because if that was the case, then it means everyone who has been employed for 10 years, they're all qualified to be a senior practitioners, as long as they have the relevant qualifications, or then they belong to a professional body. So the experience that is required, it is the experience in business turnaround or business turnaround activities, or in the business rescue space.
Elma, can I expand on Vianney's answer there, please? Prakash from the Institute of Accounting and Commerce.
Yes, please do.
Elma, I'm the CEO of the IAC, and I just want to expand on Vianney's answer there. When a member applies to a recognized controlling body to become a business rescue practitioner, what we do is they first, besides filling all the documentation and application forms, we have a special application form for a letter of good standing. That application form asks a lot of questions as to the experience and so forth of this person. So remember, a business rescue practitioner is not an accountant, is not an attorney, is not an auditor, is not a businessman. It's a combination of all of them. It's a different, what we call a different animal altogether, right? So I myself, for example, for IAC, I go through that application for a letter of good standing. We have set as IAC. And I know every controlling body does this as well. They've got their own criteria, which is very similar to, we all are very similar though, as Vianney said so. I will then authorize my membership department to issue a letter of good standing to a certain business rescue practitioner. So then only they can take that letter of good standing and go to CIPC and make that as part of their application for a license. So I hope that will give more insight as to how the junior practitioner is appointed without having had no experience. So we as a controlling body, we are very particular, we are very hard. We ensure that the person, before giving a letter of good standing, because remember, once we issue a letter of good standing and they take that to CIPC, CIPC does not go back and check the person out. They depend on the controlling body. So we are very, very particular with that. Thank you very much, Elmo.
Shut up.
Thank you, Prakash. Then next, I want to give Senzo a chance. He's got his hand up. You're welcome to ask your question. Senzo, you're welcome.
Hello?
You can. Yes, we can hear you. You can ask your question.
Okay. My question is a simple one, I think. When is business rescue deemed to have commenced? Voluntary business rescue, that is.
All right, Senzo, the Act is actually, Section 129 is very clear. It can only take effect once the documents has been filed with the CIPC. And when you go look at the definition of file within the definitions of the Companies Act, it means that we should have made sure that all the documentation meets all the relevant requirements. So although you may submit today and you think everything is right, we still have a duty to make sure that everything is correct. What we will do is we will then, if we process tomorrow, for example, we will put today's date as the effective date of the proceedings. The proceedings do not commence on the date of resolution by the directors or members of the CC. It's basically when it's filed with us and when once we have confirmed that everything is in order. So you rely on the date that we state as the effective date.
So it's the date that it's stamped on the documents that are returned.
Yes, but as from last week, not last week, the week before, we no longer stamp the documents because we had to implement work from home procedures. So what's currently happening, we issue a confirmation letter that states we've received the document, we've put it into business rescue, and that the proceedings has commenced on a specific date.
Okay.
My question is just when gaining your junior practitioner's license is 0 to 5 years, and you then want to apply to the next level, what is considered business rescue experience? Is it being actually appointed as a practitioner, or is it working together with a practitioner? What is actually considered business rescue experience? Thank you.
So what is considered as a business rescue experience? It's when you are actively engaged in the business rescue activities.
Okay, so maybe, I don't know if this is the right time, but I'm engaged in business rescue unlimited, quite a few, business rescues, and I'm actively engaged, but when I applied, my points are not considered because I'm not the appointed practitioner for those rescues that I've applied. So I was just trying to understand if there's a way to deal with this, or do you actually really need to be appointed as a practitioner?
No. There is a way of dealing with it. Remember, we rely on the CV that you provide us. For example, a person can say, I am assisting in the business rescue, or I'm assisting the practitioner. You can assist the practitioner by sending the post. You can assist the practitioner by writing minutes. You can assist the practitioner on different things. So if you do not provide the information that will assist then the sitting committee to then derived at the important information, and then it's difficult, because assistance is just assistance. So that is why we require a detailed CV that will also give us the information. So other people, they will think that because you're saying you are working with the practitioner, the fact that you're working with the practitioner will give you want to know your engagement. Others, they are working in the practitioner, probably others, they are receptionist. They can't say I'm assisting because they probably make the files and all those things. We can't say then they are a junior or a senior in experience because of their working with the practitioner. You must give us your involvement in the business rescue activities.
I appreciate your response. Thank you. In my specific case, I did give a very detailed, and I actively take part in my rescues. But the response from CRPC is that unless you appoint a practitioner, your points don't count, and it just conflicted to my application when I applied for a junior. So I'll just follow up with. I'll follow up. Thank you.
Sure.
Thank you. Can you hear me?
Yes, we can hear you.
I have a question. I see quite a few people have the same question I have. It's about the 3-yearly renewal of the license requirements. I didn't see any response to that. Did I miss it?
Yes, you missed it. The response was that at the end of the period, then your license lapses, and all that you need to do then is to apply for the renewal, meaning that you can send a letter to our email addresses, either cor126.1@cipc.co.za or to cor123.1@cipc.co.za.
Okay, there's somebody now that has a hand. It just shows us business rescue webinar guest. So please, if you put up your hand,
Hi.
You're welcome to ask your question. Yes, please.
I can't pick up where the icon is to put up your hand, so I just unmuted it. Right. I've got a question. Are you hearing me clear?
Yes, we can hear you.
Okay. If a company has liquidation orders pending but not finalized by the court, so obviously if you go into the system, you'll see pending liquidation orders. Can the company still apply for business rescue?
All right, the Act is quite clear. The section says initiated, and there's also case law surrounding it. So basically what it means is it's a race of time. So the proceedings has been initiated as soon as the court has issued, the attorney has taken the documents to court to get a case number and stamped by the registrar. That's when the proceedings gets initiated. Does that make sense? So it's who goes to the court first to start the legal process, or the decision made by the directors. Initiate does not mean you now need to wait for a court order for provisional liquidation. It's when the court stamps your notice of motion. That's correct. So let's say you are appointed today, right? Tomorrow, the sheriff serves the notice of motion to commence liquidation proceedings on you tomorrow, but the court stamp dates yesterday. Then the liquidation has already been initiated. It's literally a race of time as to what happens. As in my presentation said, we had a case where both the resolution to commence business rescue and the initiation of the legal of liquidation proceedings all happened on the same day. We actually had to go into time. What time of day, which one occurred, to know actually what the status of the proceeding was.
Okay, thank you.
Then next, the order will be Andrew and then Charles.
Alma, sorry, there's been a gentleman called Charles Backer that has been putting his hands up for quite a while.
He's had it up and then he's had it down. Perhaps let's just give him a chance first. Charles, if you may just ask your question, then we'll come back to more people after you.
I hope you can hear me. I'm doing consulting work for a few clients, but I'm a junior consultant at CIPC. But my clients is doing turnover of about 500 to 600 million a year. So they're big businesses, and I've been doing that for them for 6 months or so. But my problem is now I've done all this planning work and things to turn that business around. But because I'm not qualified as a senior practitioner, if that business now goes into business rescue itself or liquidation, will I have to get somebody else to take over for me, and then can they rely on the work that I've done already, or will they have to redo all that work?
If then the company is too big for a junior, then there's nothing wrong for a senior practitioner to work with the junior. And secondly, there is nothing wrong for a practitioner to use the work of the junior if they see that work as valuable for the rescue that they are to conduct. But we can't say they must, but it depends on the practitioner upon their investigation if this information is valuable for them to make a breakthrough in the rescue of the company.
But will that client then basically have a say in to tell the new practitioner to rely on that work, or will that be entirely up to the new practitioner that takes over?
Yeah, the company's interest is to rescue the company, and the company, as well as the directors, they're at liberty to provide as much information as possible to the practitioners so that to save the company as quick as possible. So providing that information will assist the practitioners to speed up the process of rescuing the company.
Okay. All right. Thank you.
Okay. I think we're going to take our last two questions. The first one will be by Andrew Patterson. Andrew, you're welcome to ask your question, please.
Thank you very much. Just the turnaround time once you've applied for your appointment as BRP, and where does one actually find the acknowledgement on CIPC's website?
Can I just get to the second part, the acknowledgement on the website? What do you mean?
Well, you used to stamp the COR 1232. Now you say you don't do that, but you'll find it somewhere on the website.
Okay, sure. So what is happening is that the turnaround time, we're trying as much as possible to keep it to 2 days turnaround time. The challenge that we're having is that there's an email address called Business Rescue, which is the email address managed by my colleague Krista, where they receive the proceedings, the reports, and all these other things. And people, they file also the appointments there, which is not correct. And it is because of what we have highlighted earlier, to say that people, they submit everything simultaneously without following the process is stipulated in law. So if it is submitted on time on the correct email address, we try by all means to do it within 2 days. Now, because of the challenges that we are having with this COVID, we are not in the office, we can't stamp. Sometimes the office is open, sometimes it's closed, no one can access the office. What we are saying is that to verify if a practitioner is appointed, what we do, we put the details of the practitioner in the company details. So where you will see the directors of the company, also the practitioner should reflect it there. So it will reflect it there. So our team, what they will do then, they will capture the details of the appointed practitioner on the register of the company, so that when you do a company disclosure, you will also see the practitioner appointed for that particular company. And what happens then, so that I take this opportunity, when the rescue ends, the practitioner cannot resign because it has ended. So what we do then, we change the status to inactive, because you can't resign because of your appointment was for the duration of the proceedings. When the proceedings end, you can't say now I come and resign. It has ended, so we just change your status to inactive, unless you have resigned whilst the proceedings were still active.
Okay, Vuyani, I hope that answers the question. I see our time is basically up. So what I'm going to do, I'm going to ask, there's 2 people who still have their hands up. It's Leslie, and then on our side, it just shows us Business Rescue webinar and the letters BW. I'm going to give you both a chance to ask your questions. Leslie first, and that we get the responses, because my concern is the meeting might cut out because we've already now reached 12:30. But Leslie, please ask your question, and then the other person.
My question is that if potential clients approach CIPC directly for an appointment of a business rescue professional, if they the procedure as such, how would that allocation take place?
Can you repeat that, Leslie?
I said, if a potential client approached CIPC directly for business rescue, first of all, would it be entertained? Or secondly, how would CIPC deal with that insofar as allocation of a business rescue professional is concerned?
So the client approaches CIPC for business rescue proceedings. Am I getting it correctly? So
That's
the
correct,
company is under distress and
Correct.
approaches CIPC.
Yeah.
And then
Yanni, I think he wants to know, will you appoint or suggest a business rescue practitioner?
Oh, no. Remember what we do, we have a list of the licensed practitioners on our website, and we do not try to promote anyone. It is the company that will then approach any people. You know, we are assuming that these companies, they interview these people that they appoint, they know what they can do, they check their work that they have done and do the reference check. We do not give them, because the minute we give them, they will think that it's a gospel, is from CIPC. So the onus is on the company to do their reference check and background check.
Okay, thanks.
Okay, thank you. Then lastly, our last person, your name on our side shows us the letters BW, and it reads Business Rescue Webinar. It doesn't give your personal name, but please, you're welcome. Ask your question, please.
Hi, yes, thanks very much. I just want to find out the current duration for licensing from when one applied till when you get the license. How long does it take?
Yeah, the licensing, it's supposed to be very quick, in a space of a week. Now, currently, because of these challenges, because of we're working from home, so it's a consolidation. But the only challenge that we're having is this back and forth, trying to get the information. So if the CV, it is comprehensive enough and supporting documents and everything is detailed, it should take a maximum of a week. But if it is now we need to come again and ask, give us the details of this company, what was the outcome and all those things, then it takes longer. And we request therefore the people to send us a detailed CV where you have done work. Give us the name of the company. Even if you give us the registration number, we'll check it and tell us what happened, what was the outcome and all those things, so that we can be able then to evaluate that particular information that you're giving us. But if you give us the information that is not complete, then it makes it difficult for us. Then it is a back and forth trying to contact you and say, where is this and where is that?
Okay, thank you, Vuyani. I am sorry that our session has come to an end.